Right, so our next session is another panel with some amazing speakers. It contains essentially the essay question: the climate crisis is a human rights crisis. I mean, that's effectively what has been put before the expert panelists that are coming up. And although it doesn't have a question mark at the end, I'm quite happy to treat it as if it does, because it's a challenge, a way of interpreting the climate change crisis and the way we ought to respond to it in law. I couldn't help but recall when I used to teach this subject that it was one of those classes that really worked, that it produced a sort of higher level of engagement in the students. And I think this is partly because there's a very good academic, rational, intellectual way into the understanding of human rights in relation to the environment generally, but specifically on climate change. But it also engages an emotional response. It feels like a subject that matters if you're a student. And I have good memories of classes on human rights and the environment where that combination of intellectual curiosity, excitement about experimentation, what new ideas might work, what new rights might develop, were combined with a feeling that this subject mattered, and it engaged a response to the subject that was attractive and alluring and produced really good quality work. So here we are. We have assembled this group, and it's a marvelous group, and we're going to go in the order I have, starting with David Boyd. Hi, David. UN Special Rapporteur on Human Rights and the Environment, Associate Professor of Law, Policy and Sustainability at the University of British Columbia. So you have the essay question first, David.
Well, thanks very much, James. And in my role as UN Special Rapporteur, I just want to start with a story. You know, one of the elements of this role is to do country visits. And my first two country visits were very much focused on climate change and human rights. 2 years ago, I visited Fiji. I visited a village called Vunidogoloa, which is one of the first communities in the world that had to be completely relocated because of climate change. And that was a striking experience. But even more memorable, I had a meeting with a group of about 20 Fijian children that was set up by UNICEF. And I asked these children, you know, do you have thoughts about climate change? And there was a 10-year-old girl named Akiri who said, you know, when I was younger, we used to go to the beach on Sundays for picnics with my family. But now I'm afraid to go to the beach on Sundays because the ocean seems angry to me. And I just thought, my God, what more powerful testimony could we have to the fact that climate change is a human rights crisis? And then last week, where I live in Canada on the West Coast, we had temperatures of 50 degrees Celsius. I mean, this is completely insane. Close to 1,000 people dead. The town that set the temperature record vaporized. Yesterday, a scientist said probably billions of marine creatures dead from the extreme heat. This is an absolute global emergency, and we have to start treating it as such. So when we turn to the question of the role of the courts in this, and you know, I hear this argument about the separation of powers. Well, look, human rights represent a sacred covenant between people and our elected representatives, enshrined in international treaties, national constitutions, and legislation. If legislative and executive branches of government violate that covenant, then courts are absolutely justified in providing citizens with effective remedies. That's the heart of the role of the judicial branch. And too many governments today treat human rights as if they're some kind of a policy option. But respecting, protecting, and fulfilling human rights is not a policy option for elected governments. It's one of their most fundamental obligations. So I believe that rights-based litigation has a deep legitimacy that empowers, or should empower, courts to feel quite comfortable in holding governments accountable to their human rights obligations in the context of climate change. And that's why it's also critical to have an independent judiciary as an element of the rule of law. The second question I was asked was about this criticism that somehow climate litigation is a threat to democracy. Well, come on. The threat to democracy is the powerful vested interests that have sabotaged climate science and blocked effective climate action for decades. I'm talking about powerful corporations like Exxon and Shell that have used lobbying, fake science, and other nefarious strategies to bend governments to their will. That's the threat to democracy. As I said, courts have a legitimate role to play in holding governments accountable to their human rights obligations. And I actually think courts have been remarkably restrained so far. They have ordered governments to meet their commitments in cases in the Netherlands, France, Germany, Belgium, Colombia, and others. But none of those courts have tried to tell the governments how to meet those commitments. So these arguments about serious threats to democracy are just another duplicitous, dangerous form of climate denialism and delay. So here's what I'd like the judiciary to do in terms of these climate change and human rights cases that are coming before them. Number one, treat these cases as extraordinary emergency applications, reduce barriers to justice, relax standing rules, fast track cases. And in fact, that's what the European Court of Human Rights, to their credit, has been doing with the first climate change cases to come before them. Incorporate recognition of the climate emergency in applications for injunctions to stop fossil fuel expansion projects. Be open to using stronger remedies, such as the remedy of continuing mandamus, so that if governments fail to fulfill court orders, courts remain seized of the matter and can impose stronger remedies. Follow the Human Rights Committee's General Comment 36 on the right to life, which states that human rights law must be informed by environmental law and vice versa. Ultimately, justice is at the heart of rights-based climate litigation. And I'm reminded of the famous words of Lord Mansfield in a famous 18th century slavery case that set a black man free and dealt a blow to that vicious trade. And Lord Mansfield said, "Let justice be done, though the heavens may fall." Finally, in terms of the question about the right to a healthy environment, the right to a healthy environment is a critical part of the solution to the global environmental crisis, which includes not only the climate emergency that we're focused on today, but also the collapse of biological diversity, pervasive pollution, and the surge in emerging infectious diseases of zoonotic origin. Research by Professor Annalisa Savarese already indicates that the right to a healthy environment increases the likelihood of success in climate litigation, although admittedly the sample size so far is small. So ultimately, we need to recognize that everyone everywhere has the right to live in a healthy environment. And I'll stop there, but just to say, courts have a critical role to play in this, and so do lawyers. So thanks to all of the people here who are part of this movement for climate justice.
Thank you very much, David, indeed, for that presentation. And these are themes that are going to be central to the work of this group, but also an encouragement to keep going along these lines. And the next person to speak has shown great courage in dealing with this issue at a young age. Vanessa Nakate, who is the climate activist and founder Youth for Future Africa and the Rise Up movement. Vanessa, floor is yours to deal with this question on human rights and the climate crisis.
Thank you so much. I know that climate change is the greatest threat facing our lives right now, and the climate crisis threatens many human rights, the right to life, food, health, housing, water, name it. And with the rising global temperatures, with the planet continuously warming, more human rights are going to be violated. I come from a country that has one of the fastest changing climates in the world, and that's Uganda. Because of these temperatures that are continuously rising, the weather patterns are changing. Our livelihoods are being affected. We are experiencing extreme weather events, from the floods to the landslides to the droughts. And this is affecting our livelihoods. Climate change is more than weather. Climate change is more than statistics. If people are spending nights without having access to food, if women are walking long distances to collect water for their families because of the dry spells, if children are dropping out of school because farms are destroyed and many families depend on the food that they grow so they can sell it and take their children to school, we cannot have any more, girls being forced into marriage because of climate disasters. So this is an issue that is happening right now. Human rights are being violated right now because of the inaction of the leaders, because of the continuous burning of fossil fuels. And yet we cannot eat coal and we cannot drink oil. But after realizing how the climate crisis was impacting our lives, we decided to speak up. We couldn't stay silent. If the present is catastrophic, then what kind of future should we expect? If the present is scary, then the future is much more worse if nothing is done about this. But even as we try to demand for justice, to demand for help, to demand for action from the leaders, we are continuously finding smaller and smaller safe spaces for us to protest. It's becoming harder for activists to protest and demand for climate justice. We've seen activists even in Kampala, in Uganda, being arrested for striking for the climate. And this isn't just an experience of activists here, it's an experience of many activists across the world. So our right to health is affected, our right to life, our right to education, housing is affected, and even our right to demand for a future that is sustainable, a future that is healthy, a future that is clean is also being denied. And this is why we are looking to the courts to help us. This is why we are turning to the courts. We need judges to help us defend our right to protest peacefully. We need judges and courts to hold leaders and corporations accountable for the climate crisis. We need the law to demonstrate that climate action is not a choice, it is an obligation. We cannot eat coal because it's killing millions of children from where I am coming from. We cannot drink oil because it's affecting millions of communities because of short and greed profits for corporations. My future and the future of millions of young people all around the world is in the balance. We need the law to help protect us. We need the law to help protect our present. We need the law to help protect our future. We need the law to help protect our planet. We need the law to help protect our human rights. Thank you.
Wow. I was going to pause and round of applause. If only we were in a room together. Look, that one always wants to stop and return to those themes, but forgive me, Vanessa, if I just move on and get the other speakers to speak, and then we'll see where we can come back to these themes in a moment. Let me go to Manuel Pulgar-Vidal. Hi, Manuel. Global leader of Climate and Energy WWF, former Minister of the Environment of Peru, and President of COP20. Manuel, floor is yours.
Thank you, James. And let me start by saying that I think that through this event, we are celebrating. We are celebrating the resolution of this Dutch court in relation to shale oil. We are celebrating the resolution of a German court in relation to the German targets. And it is interesting because that is something that used not to happen. In the past, when we had these kind of resolutions, journalists, media used to be surprised. But now I think that everybody has agreed that it is a reason to celebrate. So I am wondering why, what it has changed. And let me start by saying, and David, you can confirm it, that we are 1 year close to celebrate the 50th anniversary of the right for a healthy environment. For sure, in 1972, it was not written in that sense, no? But it was the beginning of a right for a healthy environment. And I remember very well that during the 80s, early 90s, used to be courts who made that right a fundamental right, a human right. And it was after that in many cases, that right was codified and recognized by policies and recognized by laws. So tribunals and courts used to have that role, but after that, unfortunately, James, that role was lost in some way. And we went into a time in which the right for a healthy environment was too much related to instruments. So it was the role of the court to certify or verify if somebody was fulfilling the maximum permissible limits or the environmental impact assessment and all of that. And I think that we lost a lot of time by having that kind of resolution. But with this resolution of the Dutch court, we are recognizing the importance of having the environment as a fundamental and a human right. And that is why probably it is a time to celebrate. A second idea that also it is interesting to be analyzed, it is that fortunately, in many of these cases, in, for example, climate, we are talking about a legal instrument that was adopted with a characteristic of non-binding. And that is really important because we now have gotten a good resolution of a court in the Netherlands based in the Paris Agreement and in many other instruments that are non-binding. Sometimes lawyers are used to fighting, thinking that probably it could be better to have binding instruments. And in my point of view, it is not about binding, non-binding. It is about how well developed, how well structured it is an agreement, and that could get traction in the level of the courts. And I think that is why the importance of the Paris Agreement, because the Paris Agreement, despite that it was adopted as a non-binding instrument, it is probably one of the most smartest instruments that we have ever developed in relation to the environment. And that moves me to the third. I think that this connection in between human rights and climate, also it is connected that we have agreed in some way by consensus a collective vision for the world. And that is really, really important. It is amazing that nobody is doubting that we shouldn't raise temperature in more than 1.5. That is crystal clear for everybody. Even more, the Paris Agreement didn't say that. The Paris Agreement said well below 2 degrees. But it has been the science who finally adjusted that threshold into the 1.5, and nobody is contesting that threshold. But more than that, now everybody is talking about this concept of net zero. So it is interesting that for the current planet, for the current world, we have a clear vision for the world by the end of the century, no more than 1.5, by the mid of the century, net zero, and by 2030. So to raise ambition in more than 50%. And that is why the German court is saying to the German government, your target, it is not enough, because we have agreed in that collective vision, and that is really important. And that moves me to a fourth element. It is not just about courts or policies. It is also about the role of science. And again, I think that as with tribunals, the science has played a mixed role. So we used to have a strong science that made possible the UNFCCC in '92, because it was mostly because of the creation of the IPCC that the Climate Change Convention was adopted. But after that, we had a strong divorce on decision makers and science. But fortunately, and mostly since the 5th synthesis report of the IPCC, decision makers are taking back science to model what it could be the future of the world. And the courts are defining resolution based on what are those models that science is putting in front of us. That moves me to a fifth element, that it is this connection in between human rights and climate change. It is about the right for a healthy, not environment, for a healthy future. And that is something so important. We are not talking about the present. For sure, the present, it is showing to us, because of the evidence, how catastrophic climate change could be. But these resolutions that are connecting human rights with climate are saying to us that if we are not able to take action today, the consequences could be even more catastrophic in the near term. So those kind of resolutions are defining in some way the right for a healthy future, the right for the next generation. So the ethical side of those resolutions are really key and strong and important. Also, you made to me some questions, one of those around COP26, how important it could be COP. Look, everybody knows that we are in a time in which we are implementing an agreement. So we know that the elements to be negotiated through a COP are becoming less than used to be in the past. And that is natural because we are implementing, and what we do need, it is not more negotiations, but more action. But despite that consideration, COPs are still an important room that also is recognizing a right, the right for the least developed countries to take decisions and to be part of framing the future of the world. Multilateralism, it is a key element to have those kind of decisions. And we shouldn't jeopardize the multilateralism, even in case in which we are talking about implementation. And the COP also, it is important because now we are focusing not only in ambition with all those clear thresholds and objectives, but also with the means of implementation. And in that sense, the NDCs, the National Determined Contribution, are key. And the NDCs could play key roles for domestic decision of tribunals in the domestic levels. Because the NDC, it is the domestic plan, it is the national plan that should reflect how ambitious the country it could be and what are those actions that they are planning to take to achieve those objectives. So if COP is going to continue strengthening the role of NDC, but also with as means of implementation, the role of finance, the role of the non-state actors, that would be critical. Let me finish by saying, because one of the questions were related to how can we best balance human rights, climate, and energy. And in relation to energy, also let me say something. The recent report of the International Energy Agency, that it has been published less than a month ago, it is saying that by 2050, 90% of the source of energy will be non-conventional renewable energy. And that agency is not including any reference in their model of traditional fossil fuels. So that is a key element. Again, we have agreed a vision. We know that traditional fossil fuels will not play a role in this planet. We know that we must now phase out coal, later diesel, then gasolines, and finally natural gas. So the future of the world, it is without traditional fossil fuels. Let me finish by saying that a good balance between human rights and climate, it is about the vision, it is about law and policies for sure, it is about the role of courts, the level and importance of science, and finally activism. I am used to thinking now that before of the beginning of the pandemic, we used to have a very good activist, Greta Thunberg. After the pandemic, I am fully sure that we will have thousands of Gretas because the young people has been more aware of what are the level of damage that the human being can create to the world and how much it is in our hands to bring those solutions. So thank you, Nancy.
Well, thank you very much, Manuel. That's there's lots there we might want to come back to before we close off. But let's move on to Mary Robinson, former President of Ireland, Chair of the Elders, former UN Special Envoy on Climate Change, and the High Commissioner for Human Rights. Mary.
Thank you very much, James. And I'm delighted to begin by reinforcing and building on the points made by my friends who began, David and Vanessa and Manuel. It's lovely to see you all again, and you, James, as moderator. I think Vanessa eloquently made the case that the climate crisis is a human rights crisis. I would just add a simple fact. If we don't do the right things and lead to our own extinction and the extinction of other species who are dependent on our bad deeds, the earth will recover. You know, Mother Nature will come back shining, smiling, because there'll be no fossil fuel. We're the ones who will suffer. So take away that question mark and never put it back, James. There is no question mark. The climate crisis is a human rights crisis, full stop, and very underline it. And the world is running out of time, as we know. But this year, as Manuel has emphasized, is a key window of opportunity for raising ambition, because ahead of COP26, we know that governments are updating their national climate plans, their NDCs, and also companies in all sectors are setting voluntary targets. And it's because governments and industry are way behind where they need to be, that citizens and indeed investors are increasingly turning towards the courts, and judges are increasingly stepping up and coming off the sidelines and holding governments and businesses accountable for inadequate targets or inadequate implementation. I recall, James, when the International Bar Association came to Dublin in 2012 and invited me to be a speaker, that I lectured them, which I'm entitled to do. I'm a granny and I'm chair of the elders, and told them they were way behind the curve, get their act together, form a task force on climate justice. And they did all of those things and are now, a very good lawyers championing. Equally, the courts have stepped up, as we're hearing. It's really, encouraging to see the almost weekly examples of innovative climate litigation, and more needs to arise because it's helping the momentum towards COP26. For COP26 to succeed, countries must first of all submit updated national plans that collectively keep 1.5 degrees within reach. The survival threshold, as that is for many vulnerable countries. So far, these plans fall short, and some of the major emitters still haven't even put forward their NDCs, such as Australia and China. Companies too must set science-based targets. And secondly, we have to deliver on the climate finance, the famous 100 billion a year, which is a kind of a long promise to become a kind of token for developing countries of trust. The G20 has to step up and put that to bed, that 100 billion, because it then has to attract trillions in private finance. It's the kind of basis for that. And it is inspiring to see young people both bringing and winning cases. And I just want to refer to two of those cases because it's worth looking at them in a little more detail. In April, we've had an Irish case, which was very important under our constitutional law, and the government had to act. But I was particularly impressed by the German Supreme Court in April, which ruled in favor of young plaintiffs and found that the German government's climate law, which was to reduce emissions by 55% by 2030 on 1990 levels, was putting future generations at risk by leaving too much of the burden to the years after 2030. So the judges said the law risked forcing future generations to engage in radical abstinence. I'm quoting the court. In response, it took the government less than a week to come up with a new draft of climate goals to cut carbon emissions by 65% by 2030 versus the original 55%, and to push forward its net zero target from 2050 to 2045. So you can see how effective litigation can be when a government rightly complies with the court. And then a few weeks ago, the courts in Australia found that the Australian government had a duty of care to not act in a way that would cause future harm to younger people. The case, as you probably know, was brought by 8 teenagers and an 86-year-old nun, God bless that 86-year-old nun, to prevent the approval of a massive coal mine. And while the injunction wasn't granted, the court did establish a new legal precedent of duty of care in negligence. The court's judgment found, and I quote, "It is the children who are most likely to remain alive long enough to fully experience the wholesale destruction by fire of much of Australia's forests. Each of the children is exposed to a real risk of harm from bushfires, and each of the children is exposed to a real risk of death or personal injury from heat waves induced by climate change." So we have, courts that are really stepping up now, but I agree with David, they need to do more. They need to really see these as emergency litigation. I agree with that. And yesterday, because I talk about climate justice every day, as you probably know, and take part in a fair number of panels, as we all do, I was on a panel invited by UN youth delegates and some governments as a side event for the high-level political forum. And it was about climate change and human rights. So very much the subject we're talking about here. And I learned, because I didn't know this, that the world's Youth for Climate Justice, which is a group of young people that have come together, the world's Youth for Climate Justice, which originated in the Pacific Islands, has asked the United Nations, or begged the United Nations, to request an advisory opinion from the International Court of Justice on the effects of climate change, on the human rights obligations of states, and the interpretation of intergenerational justice. And as we spoke on that panel, I was very enthusiastic about that, because I think an advisory opinion of the International Court of Justice could be much broader than the evidence that you have to bring, the evidence of causality, etc., that you have to bring before a court to try and get a judgment. I think it could go into the layers of injustice that I put together to say we have to have a climate justice approach, that the poorest countries are most affected, that there's a gender dimension, the intergenerational injustice, the injustice of the pathways to development, that we industrialized countries built our economies on fossil fuel. Now we have to wean ourselves off and do it with just transition. But that developing countries need the energy, and we're not showing the solidarity. And then the fifth injustice is the injustice to nature. I think in an advisory opinion, it would be possible to really capture a lot of that. And it's time the International Court of Justice stepped in, because it is a crisis.
Well, if I may, could I just start back with you, Mary, and then go around the group? A couple of the things you mentioned, a couple of the incidents you mentioned, are very clear examples of how some kind of activism has combined with some kind of judicial intervention or reasoning, and in turn combined with political action. So that we discussed a lot separation of powers yesterday, but you have experience in Ireland of that coincidence. I don't mean that in a sort of literal sense, but that bringing together, convergence, if you like, of a movement of ideas, a significant constitutional law case, and a change of politics, which in turn has led to a significant shift in the law of the land in Ireland. And you've also experienced a slightly different context, long history of suppression of rights, leading to a very significant shift with same-sex marriage, new legislation. So we discussed a lot yesterday some of the despair associated with the length of time it's taken to do this. And I wanted to encourage the audience to think that these things can go slow, and then there's a change of consciousness, and there's a fundamental shift in the way the law works for a society. Could you just help us focus on that for a moment to see where it might go?
I have to think that the shift in focus, which is definitely happening and is very welcome, because it is all kinds of activism, including bringing litigation and some of it very successful litigation before the courts. I have to say it's because we've changed the communicating about climate. I think to a fault, the communicating earlier was about science, about technology, about melting glaciers and polar bears. Now, I love polar bears, but it wasn't about people. It wasn't about human rights. And I think it was good that in 2004, the Human Rights Council became seized by the Maldives of it being, and we had a number of regulations, and David and other human rights experts have been leading on it. But it took a while for that then to penetrate more. And I really thank the young climate activists, Vanessa, whom I've met many times and listened to many times, and we're good friends at this stage, and her colleagues, in bringing out the intergenerational justice in their very direct, very personalized way, in the way they tell the stories of their different parts of the world that are suffering the existential threat. And I want to remind us, and Manuel would know this very well, he was in charge of Lima before Paris. The Paris Agreement doesn't it doesn't owe itself to the fact that China and the United States agreed that there would be a Paris Agreement. Yes, that was very important. But what was even more important was the work of Tony de Bruyn of the small island states, and then leading the High Ambition Coalition, which had one real key thing: to get 1.5 degrees into the text. So we got a new goal in Paris, staying well below 2 degrees and working for 1.5 degrees. The scientists had never really properly studied this. Therefore, the climate agreement asked the scientists. They studied it in October 2018, and that gave us our whole new urgency. And thank goodness for the small island states, the indigenous peoples, the poorest countries, the civil society. We need a similar impetus for COP26. And we need it despite the fact that we have a problem of not having equitable access to vaccines. Everything is connected. You know, the injustice of not having equitable access to vaccines may harm a successful COP in Glasgow if we can't get those voices at the table.
I fear it is already a very, very significant issue in the COP26 preparations, the inequity in vaccine distribution. And Mary, you played a very significant part in that. It's the only time in the long history of these negotiations where the agreement got better in the last 3 days. And you played a part in that as well, along as my old colleagues in the small island states, and also literally a women's group, the Lionesses, where, my word, they were effective. And there was high levels of trust between them. They trusted each other. They worked together across all sorts of boundaries. And that was the best moment probably in 30 years of work on negotiations. And you were a part of it. Vanessa, I'm going to come to you because this is the right way to characterize the problem, we think, to reduce it to the essence of humanity, human rights, inalienable rights, rights associated with being human. And you touched upon it, but we also had a discussion previously about defending the defenders. There's real risk in activism in many parts of the world, real personal risk. And I just thought we ought to dwell on it a little longer. The fact that those who are effectively speaking up on all of our behalf, right? You know, not everybody is going to join the front of the queue in a protest. In a sense, by raising the alarm and advocating for action and centering it on human rights, you are representing all of us, and yet you're at risk. I'd just like you to dwell a bit more on that, a bit more of the experience that you and others have, so that it helps us focus on the real world situation that we are in. Vanessa.
Yeah, thank you so much. I remember studying activism and already knowing the situation in the country where I'm in, and most of the activism we would do, we would go to schools, inside schools, and speak to students and do strikes within schools. And there are always questions of, why aren't you going to the street with the students like everyone else? Why are you doing this within schools? And it was always a time of explaining that if someone in Germany or Sweden steps out and goes to the parliament and strikes, it's not a similar experience, you know, for me to go to the parliament and strike and it's all okay. Actually, you cannot stand at the parliament for, you know, more than 10 minutes without being asked what you're doing there and without being asked to leave. So it was always a time of telling people that activism here is different from what you see in other countries because there are no safe spaces for us to do activism. There is a time we organized a strike in front of an environmental organization, and still they threatened us with arrests, an environmental organization. And we were all thinking, wait, we are making your work more smooth by demanding for a safe climate, a safe environment, what you're doing. So why is it that if we come here and strike in front of, you know, your building, then it is a problem? Then we are attacking you, and yet we are all for the same thing. And this year, 3 of the activists in Rise Up movement, they were striking in front of the parliament, and they were arrested, you know, for holding placards and standing there for more than 10 minutes, you know, and taking photos from there. So this is a daily experience of activists not being able to step out and do protests peacefully the way they want because of a fear of protests. We've had some people say, I can't join you for your strikes because they are very risky. Honestly, I personally don't know how. I have never been arrested. I can say I've been so lucky all this time. I've been going to the streets, and yeah, but it's really an experience of very many activists for the fear, you know, of doing activism. And with this pandemic and switching to online activism and sharing pictures, you know, from home, it has been kind of, you know, it has it has made the world to, do a part of what we've been doing all this time. And I don't know how best to bring it out, not going to the street. However much we were following guidelines of, the pandemic and keeping everyone safe, it was also a time for us to protest without feeling like, oh my God, we are not going to the parliament. We are not going out on the streets like everyone else because everyone is striking from home. So it feels like, oh, we are all doing this and you don't feel much pressure. Yeah, so it is an experience that I have seen. It's an experience that many activists have seen in my country and across the world. And it's really important to, start talking about that issue, because if we cannot speak up, then who is going to speak up? If we don't talk about our stories or our experiences in our own communities, then who is going to do that for us? This is why we are looking to the courts again to help us, to help protect, our right to peaceful protest.
So you've had experience. Oh, we've got a bit of echo here. You've had experience, Manuel, in your part of the world. I know how you started life out in environmental law. I know your history, and there were some difficult times where you needed to get access to justice in order to be able to make claims in courts. And this idea that there's actually a two-way flow. You've got to have a legal system that gives access, and also a legal system that protects those who want to make arguments in the streets to, encourage the government to do more. And this sort of dual function of the legal system to protect and provide access to the rule of law is something that has to be tested in sometimes very difficult circumstances. Maybe you can recall some of your early days, Manuel, and just go back over how this can be done effectively so that human rights becomes actualized, it becomes really available, and access to justice is real, not just a paper promise.
Yeah, thank you, James. Yeah, you are moving back to the 80s.
Yes.
I am involved in environmental laws in 1986 when we created the Peruvian Society for Environmental Law.
Yeah.
It was our last year in the Faculty of Law at Universidad Católica in Lima. And yeah, it was a time interesting because Peru is one of those countries that probably was a pioneer in recognizing the right for a healthy environment. But interesting, it was recognized in our constitution from 1979 in the chapter of the economic topics. I don't know why. No, in 1979, it was recognized there, but it was good. At least it was there. And we started by accessing to justice without any clear foundation to do that, no? To ask judges to recognize that as a fundamental right, and we got it. And when we did it through injunctions, that was the way that we did that. The first actions that we presented, it was injunctions to protect the protected areas, some protected areas in Peru, and we got it. And that is why finally that right was finally scaled up into a fundamental right in our current constitution from 1993. But also, we got some other legal instruments in our constitution, also because the role of tribunals, the habeas data, access to information. Peru, it is probably one of those countries that has that recognition in the constitution. So the access, and also we went into tribunals to ask for some public information, and we won in the Supreme Court the first habeas data ever in Peru by using tribunals. And it was after that kind of resolution that finally, through our first environmental law, that it was in 1990, it was the El Código del Ambiente, the environmental code, that those rights were well recognized in our law. So that is why, James, I am all the time thinking how much we should start by putting things in law, or how much we must do it by activating tribunals. And let me say something also, I am going to challenge David to think about that. you know that we are working in what it is called the Global Pact for the Environment, no? And we have very good friends. Probably they are here in this event listening. I am all the time saying or wondering if it makes sense to codify what we have already gotten since '92 by the Rio Principles, or what we should do, it is to think of what are those new principles that it has been developed in the last 20 years that should be recognized as that. For example, in 2022, as part of our celebration of Stockholm plus 50. What I am trying to say, it is the Rio Declaration, a non-binding instrument, was enough strong to have tribunals recognizing as fundamental rights many of those elements, and we did it, and we didn't need to codify it as a way to have the tribunals giving good resolution. So the point is, what else it could be developed as principles in this time of climate change? Because when we thought in '92 in the principles of the Rio Declaration, for sure we were not in the current times in which there are new challenges of the world. No, we have climate as one of those threats. So I am thinking what else we could do. That is the first. Let me finish by saying two more things. Coming back to the resolution of the Dutch court. It is interesting that in some way, the Dutch court, it is giving in an indirect way some content to this concept of net zero. Because as you know, many companies are defining different climate claims by using carbon neutrality, carbon positive, net zero, etc. No? But the point is that still we are under discussion on exactly what does it mean, the net zero. But this Dutch court, by saying to Shell, you are not doing your best effort to raise a target, it is giving some content to that net zero. And also that resolution, it could be useful to have those kind of claims well supported by science, by using the science-based target. Probably resolutions in the future will say your target, it is not well supported by science. And that is why you should review it and bring it back. So that is the second element. And my last point, James and friend, also to you, David, if I can, it is that all of this, it is possible because we are talking about measurable things, carbon. But what about resilience? No? How could we move tribunals into those kind of resolutions when we have resilience as the key objective? That it is not, at least it is not easy to be measured. No? That is probably the next step when we think about adaptation, resilience, and the role of tribunals.
So that's a nice pass to you, David. I mean, there are a couple of themes here I'd love to develop in the limited time we've got. One is this tension between codification, legislative drafting, and access to tribunals, testing tribunals' capacity to interpret existing law or expand the range of interpretations available through their decision-making, but also this challenge to think of new expressions of rights that might be more specific, might possibly be more justiciable than some of the more general rights, but still have to be argued for and established one way or another, whichever route you go down. I wonder if you could just take that conversation on a bit for us, David.
Thanks very much, James. And it's so terrific to be on a panel with Mary and Vanessa and Manuel. So much wisdom here. So I'm going to talk about the way that human rights evolve over time. And the right to a healthy environment is a really fascinating example of this because, you know, as an academic, you know, I've read probably too many articles about critiques of the right to a healthy environment saying, you know, this is an anthropocentric approach to environmental problems, that we really need an ecocentric approach, which in my heart, I agree with. But part of our challenge is we need to convince governments to get on our side. And so what's really fascinating is that the right to a healthy environment, which as Manuel mentioned, started out in the Stockholm Declaration and is now recognized in law by 80% of the UN's member nations, 156 out of 193 countries. We need to get that to 193 out of 193, and we're working very hard on that at the United Nations, both at the Human Rights Council and at the General Assembly. But what's interesting about the right to a healthy environment in today's context, in this global environmental crisis, is that more and more courts are starting to interpret the human right to a healthy environment as meaning not only healthy for us as humans, but healthy for ecosystems and biodiversity as well. It's really bringing an ecocentric perspective to the human right to a healthy environment. The Inter-American Court on Human Rights created a beautiful advisory opinion in 2017 on human rights and the environment, in which they said that what distinguishes the right to a healthy environment from all other human rights is that it includes protection for forests, rivers, oceans, and other elements of the environment. And other courts have started picking that up. The Supreme Court of Mexico has said, yes, this right to a healthy environment has two dimensions, a human and an ecocentric dimension. The Supreme Court of Colombia. And so I think that's a very exciting development. I think that it's critically important that we strengthen the legal recognition of the right to a healthy environment so that it's universally recognized. And we're on track to do that. I also want to talk about, I do a lot of work with young people as part of the Children's Environmental Rights Initiative. And there is one message that they ask me to bring to adults every time I talk to them. And that is, we've had enough talk. We've been talking about this stuff for decades. We really need to focus on action, getting things done. And so I think that's really a key message. And when we look at the climate context, there are three pillars of climate action that we have to talk about. We've talked a lot about mitigation. And yes, absolutely, we need to focus not on net zero by 2050. That lets people and corporations off the hook. We need to talk about emissions reductions in 2021, 2022, 2023 to get to that 50% reduction by 2030. That's a mammoth task. It requires action, not discussion. The second part is adaptation. And my friend Mary spoke of the $100 billion that wealthy countries committed to mobilize. And for us as individuals, unless you're Jeff Bezos or Elon Musk, $100 billion is really an unfathomably large number. But in the global economy, which is close to $100 trillion, it's peanuts. It's a drop in the bucket, but it's critically important for those low income states and small island developing states. And the third part of climate action, which I haven't heard a single reference to in this conference, which is quite shocking to me, is loss and damage. Loss and damage has been part of climate action in theory since the early 1990s. Loss and damage refers to compensation, basically, for low-income countries and small island developing states that are already getting hammered by climate change. Take a country in the Caribbean like Dominica. They've been hit by 2 Category 5 hurricanes in the past 6 years, each of which damaged over 90% of the homes and buildings in that country. How the hell are they supposed to pay for that? They have no responsibility. That is a wealthy country responsibility. And so I am firmly supportive of proposals from the Maldives for an international air passenger levy. You know that $10 on every air ticket would raise $40 billion a year that could be channeled to low-income countries and small island developing states. The Marshall Islands has proposed a shipping levy, $100 per ton from shipping. That would raise $100 billion a year. But we can't just talk about those proposals. We need all of us to put our weight behind those small island developing states and their proposals to make it happen. That's got to happen at Glasgow, or that's just another talk fest, a failure. And so really I think if anything comes from this discussion, it's that we need action and accelerated action to address the climate emergency.
David, you may not know that when we and my colleagues and I founded the Alliance of Small Island States all those years ago, we tried to argue into the first agreement, the Framework Convention, a liability provision,
right? And
obviously failed catastrophically to even get close. But one of the ways we designed a system with, sadly he's dead now, Professor David Pearce, which is essentially an insurance mechanism based on emissions and sea level rise, which was the most measurable indicator of the failure to solve the problem. And I think back to those days, bearing in mind this is, late 80s really. And we first, I think, launched that proposal in 1991.
Yes.
So I really feel what you feel about how long this has taken. And of course, loss and damage was the conversation that followed that, because we were unsuccessful at building in a proper liability regime. And it could have been done in a way which wasn't, strictly speaking, punitive. It was simply distributive. And I still think that's the right approach.
Yeah, and frankly, James,
yeah.
these levies, you know, who's going to stop flying because they pay an extra $10 on a flight? I mean, you could make that $50 on a flight, and then you'd be talking about $200 billion a year. That's not punitive. It's just, it is a redistributive mechanism, but it's also a climate justice mechanism.
Correct. And the industries that are in the middle of this, the insurance industry, for example, they can manage that. They could pool resources to do that. I mean, they could facilitate it if they wanted to, if they really wanted to. And it's something that I wish we could take more time now in order to be able to develop it further. But there is an essential link between these systems that distribute resources and the vulnerabilities of those who are most affected by climate change. And they happen within countries too, as we know. The inequalities are very manifest within countries. But having spent all those years working specifically with the most vulnerable, with the small island states, who are also the best representatives of our interests, it pains me to think that you still have to change the tone of your voice and feel something like anger in order to be able to deal with this issue in a more intelligent and distributive way because of our mutual dependence. And I do think that all of you have sought ways of grounding this discussion in something that expresses our basic humanity, which also includes our connectedness. It also emphasizes our belonging to a larger group than ourselves and even to our nation, right? So I want to bring this inclusion, but I think it would be good if we could just go around and have a single last thought to pass on. Our next contribution is by video, so we may be able to do a little bit more than our allotted time. But I think it would be nice if we could have a summing up of the session from each of your perspectives, leave us with an idea that we can grapple with and make us feel like we could respond to David's challenge when we leave and do something in our lives the next day that make it more likely that we would deliver on the promise of human rights and the environment. I'm going to start with Vanessa and then go around. So Vanessa, leave us with a notion.
Thank you so much. I think I would really love to complement something that Mary talked about. And just to add that, you know, in addition to countries making long-term commitments of net zero by 2030 or 2040 or 2050, we need action now. We need action at the pace and scale that the climate crisis demands. We need action that the science demands right now. And we need action not sometime in this decade, not tomorrow. We need it now. So I just want people to not feel comfortable when leaders talk about 2030, 2040, 2050, and yet they're living more decades of environmental destruction. As these targets are put in place, more coal power plants are being opened, more oil pipelines are being constructed. So we have to keep note and see the loopholes in the targets that are being set by the leaders. Thank you.
Manuel?
Yeah, just a short comment to remind to everybody that it was just 12 years ago when we failed in Copenhagen. Interesting, just 12 years. And it is amazing how much progress we have made since that year. What I am trying to say it is that this is a gradual process in which every step counts. And in my point of view, and I am optimistic by nature, I think that the timing in which this kind of resolution, as the Dutch one, it has been released, it is perfect. Because we are entering into a new time in which, by confirming what David has just said, we must demand more clear and concrete action. And that concrete action should be clear, it should be well supported, should be adjusted to our objective. And a second element, it is that we should continue following by mentioning what Mary said about Tony de Bruyn, by continue building this bottom-up process. Because it is this bottom-up process not only by the island or by the most vulnerable country, but by the people, that we can continue making this process evolve. So we are entering in a time in which the element of a new economy are emerging, in my point of view. I hope that I am not too naive to say that, but I am sure that the economy for the next 30 years will be strongly conditioned by climate consideration. And we are entering into that new time. And because of that, the role that tribunals can play would be key.
Yeah.
Would be key, and also the role of the activists.
Yeah. Absolutely right. And enforceable rights will help. And the confidence, frankly, that we can transition to a different economy. I think we'll, by the way, I think we'll win and we'll easily in power. There are other parts of the economy that are less, less easy to reach, but I think there will be a clean energy future for sure. David, a final parting shot from you, and then I'll leave Mary to round us off.
Just to say that, this is the only planet in the universe that is known to support life. And by taking accelerated climate action, not only can we protect that incredible, beautiful biodiversity, but we will create a better life for billions of people. It's only a small minority that's holding us back.
Mary.
I think we need to treat a crisis as a crisis. And we haven't yet mentally and emotionally quite done that, especially governments, especially corporations, especially investment. It's all moving slowly in the right direction, but too slowly. So we need to build trust. And trust is built with action. It's built with the kind of action we've been talking about. We need NDCs and science-based commitments, targets by government, corporations and investment that are aligned specifically with 1.5 degrees and not out to 2050, but every year up to 2030. We need the 100 billion and then trillions that follow from that. I absolutely believe we need loss and damage on the table and discussed in this distributive sense that we've been talking about. Absolutely necessary, again, to build the trust. We need equitable access to vaccines. And I just want to say, as David knows, I'm very strongly supportive of his efforts for the Human Rights Council in September to adopt a resolution on the right to a healthy environment. We need that pushed and pushed hard.
Well, bless you all. Thank you so much for your contributions. We're only fractionally over, and that's fine. And thank you so much for the conversation, for your continuing endeavors to make this a reality. And I wish you all the very best of luck in this next critical period. And we'll close the panel there and we'll go on to Naomi's presentation. Thank you.
Thank you, David.
Thank you.